Peace to everybody. This is about the Supreme Court rules against death row inmate with rare disease. Now, I have never heard of anything like this before in my life until I just came across this. And as you can see here in the video, it's the bed where the inmate would be strapped down, and of course he would have needles injected into him. The Supreme Court on Monday ruled in a 5-4 decision against a death row inmate in Missouri who claimed that his execution by lethal injection would cause him severe harm and suffering because he suffers from a rare disease. So there was a 5-4 decision against a death row inmate, and it happened in Missouri. That it would cause the inmate to have severe harm and suffering because he suffers from a disease, and we don't know what disease it is, so we're just going to have to try to find out. Russell Buckley's challenge marked the first major death penalty case that was argued since Justice Brett Kavanaugh replaced Justice Anthony Kennedy last spring. Kennedy voted with the court's 4 liberals to put the execution on hold. So it was challenged. It was marked with the major death penalty by Russell Buckley, and so he just decided to challenge the court system, or the Supreme Court system, about what the liberals and everything, and then of course the execution was put on hold. While the Supreme Court has broadly upheld death by lethal injections, lawyers for Buckley argue that in his particular case, the disease called cavernous hemangiomas, a progressive and causes an unstable blood-filled tumor to grow in his head, neck, and throat, and they concluded that it would, if he were to go under lethal injection, he could suffer from prolonged suffocation. So this disease does have a name for it, and if they were trying to put him for a lethal injection, it would suffocate him. It would prolong his suffocation. So that's why he challenged the Supreme Court about this disease. Buckley argued the state should consider death by lethal gas as an alternative. So they want him to have, instead of the lethal injection, they want him to have the gas instead. Justice Neil Gorsuch, who wrote the opinion for the majority, emphasized that the Eighth Amendment does not demand the avoidance of all risk of pain in carrying out executions. He said that court precedent holds that an inmate cannot successfully challenge a method of execution unless the inmate identifies a feasible, readily implemented alternative that would significantly reduce a substantial risk of severe pain. So he really can't challenge the Supreme Court of anything. So there's an Eighth Amendment that does not demand the avoidance of all risk of pain. So whatever he has, he's got to deal with it, like it or not, because it's not his decision to choose his own death. Buckley had failed to present any evidence that the substitution of lethal gas would significantly reduce his risk of pain, Gorsuch said. So there was no evidence, there was no paperwork, no nothing for him to for this lethal gas that he would have allegedly was supposed to have, but instead you just got to go on with the lethal injection, like it or not. Gorsuch also charged Buckley with attempting to secure delay of his execution for the murder of Michael Sanders in 1996 through lawsuit after lawsuit. So yeah, he was. So Gorsuch charged the inmate with attempting to secure delay of his execution, and there was no way that was going to happen. That Bucklew was going to get away with. Oh, I don't want that. Well, you just gotta have to deal with that. The people in Missouri, the surviving victims of Mr. Bucklew's crime, and others like them deserve better, Gorsuch wrote. So yeah, so there are people that are survivors of Mr. Bucklew's crimes, and it was just a shame whatever crimes that he did, that he has no choice but to get the death penalty. His opinion triggered a stinging dissent from the liberals on the bench. Justice Stephen Breyer wrote to emphasize that Buckley was not attacking Missouri's lethal injection protocol categorically, but only as it applied to him because of his unique illness. So he wasn't. So they're trying to say, oh, he wasn't really trying to not attack the Missouri's lethal injection protocol, but because of his unique disease that he has, that's what he was challenging himself on, because he doesn't want that lethal injection. But what choice? And it's just all up and up right now. Breyer said that while Bucklew had established that executing him by lethal injection risked subjecting him to constitutionally permissible suffering, the majority holds that the state may execute him anyway. So no matter what he does to try to challenge this gas thing, they're still going to inject him anyway, either way, like it or not. So he's still going to get the lethal injection, no matter what he tries. Lawyers for the state disputed the findings of the medical expert and emphasized that Buckley engaged in lethally delays in fighting his death sentence. They argued that Missouri's one-drug protocol is the most humane and effective method of execution available, and that the state has no experience with lethal gas. So they just don't have no experience with lethal gas. They only have experience with lethal injections. So that's what he's going to get. And he just keeps delaying, one delay after another with the lethal injection. And, he's been accused of that, so he has no choice but to get that lethal injection. So whatever the judge says goes. You got to get that. You're going to get this punishment, that punishment, like it or not. Rare disease or not, you're still going to get that either way. Leave your comments below. I am out.